This is from Patrick. It says, I live in Texas and am married to an irresponsible woman with an arrested development and what I believe to be emotionally and biologically unstable. What can I do to get custody of this child?
Well, now, and we have to take this a little bit of grain of salt, meaning I'm not assuming that this person in Texas is incorrect at all, but we sit in front of hundreds of clients over the period, thousands of clients over the period of our career, and fortunately for our clients, we learn to discount those things that there's some question about, or a court will find some question about, so that we don't blithely take our clients' money and lead the charge into court, and ultimately they lose in the battlefield and they spend a bunch of money, and we walk away to the next client. We want, when we walk away at the end of the battle, whether we win or lose or draw, we want our client to think that we did a wonderful job. So when we have somebody that comes in like this, and that sort of and by necessity, of course, is a very brief introduction, but I want to first deal with the possibility that the court would not conclude that this person is mentally ill, and that means that that it's incumbent upon this person in Texas to be prepared to present evidence, and it's going to be evidence that has to be persuasive to the court that this is a problem that would interfere with the safety or the welfare of a child, to the extent, of course, we're dealing with a custody battle. What comments would you have, Clarissa?
Well, I guess my first question, are we assuming that this person's wanting to modify an existing custody order?
No,
or
I think he's talking about a divorce.
Yeah, he said if he was married to her. Yes.
In cases like that, I usually, if it's an initial custody determination where the burden's a little bit different, I usually tell my clients that if we can show, either a pattern of instability with mom or can actually prove some kind of mental illness, that's great. That's obviously a benefit. But if we don't have a real solid case of that, it's still very important not only to show mom's negatives, but to show your positives as a parent. And I think that's kind of where you have to focus. If you don't have a real clear-cut showing that mom is unfit, you've got to show that you're a great parent and why you're a better parent.
Yeah, and parental fitness is a relatively low bar. Now, when it's a pursuit of primary custody, then essentially there are two contestants, and you only have to beat the other contestant. So it's not necessary to establish that you're the perfect parent, but you're a better choice than the other. But notoriously, guys will come in. I'm not picking on guys, but I've just had this happen enough over my career to where I need to deal with it or talk about it. And they'll believe that they have examples of behavior that would persuade a court that this person should not have a child in their care. And I'll give you some examples of those. That mom has taken antidepressants in the past. And there may have been a time 20, 30 years ago when that sort of thing would really get the court's attention. But that, without more, is not likely to affect the outcome significantly. And the reason is that that's a relatively common phenomenon in our culture. Whether it should be or not, it is. Other examples is where mom may have, on some isolated occasions, struck the child. Now, don't get me wrong, the judge will sit up and listen if there's been any allegation of abuse, but if it's that and nothing more, and in the meantime mom has been the primary caregiver, then often it's not enough to shift the balance, to shift the scales. So you need a pattern of things that are sufficient to where a court will capture their attention. But the starting point is, what is it that will impair someone's ability to parent and will have an adverse effect on the child. And if you can't make that connection in a tangible way with your evidence, then you're not likely to succeed on that point. Now, maybe there are other points you can argue, but on this issue of that she's mentally ill, or she has other psychological problems.
I constantly ask my clients when they bring up stuff like that, I say, give me examples, and are they concrete? Because just as you were speaking, Joe, I get these examples of an isolated incident or something that maybe is a little out of the normal, but is not anything that rises to the level. And then furthermore, is there proof? Is there proof of this behavior and whatnot? And a lot of times there isn't necessarily. And then when you dig up that skeleton from the closet or whatnot, then I say, now look back on yourself. If we bring this up, what are they going to bring up about you?
Very, very good, Heather. I'm glad that you brought that issue up. And Clarissa, that's worth mentioning is the issue about the evidence. While I mentioned it just a second ago, we should dwell on it a second, and that's that it's one thing. Let's assume that there are some incidents that cause some concern, as you said, Heather. Then the issue is, what is the proof that we have? And often it's the guy home alone,
Sure.
or it occurs at family events when it's her family that's there primarily. Proof is a big issue in courts of law, and it's not enough to present things as you do to your lawyer, unchallenged in the security of his office, and when you can say what you want and say it in whatever way you want, whether it's technically correct or maybe exaggerated in this small way, or maybe it's entirely correct. But the point is, you don't have that liberty in a courtroom. There are rules of procedure, there's rules of evidence, and you got to comply with that. And it might be that you have some powerful events to point to, suggestive of this complaint, but events which you can't establish in terms of admissible evidence. Would you add anything to that, Clarissa?
No, I think you're right, and I come across that problem a lot. I mean, or even situations where, I have a client who heard from a friend that they saw a wife do this or that, and I mean, there's so many different people that you can't get into court to testify, and it's third-person accounts and things that, would be great evidence if you could get it into court, but a lot of times you have difficulty doing that.
Right. And how often, Clarissa or Heather, do we have somebody come in that says their wife has a drinking problem? You would think
daily,
regularly. You're right.
Yeah.
And you would think, well, gee, that's something that should be easy to establish. But when you really sit down and start thinking about, okay, I'm going to put this together, and you start thinking, okay, how can we do this? Well, do they shop at the same liquor store? Can we look at where they sign credit card receipts? That's a tangible example where you can back into evidence. If they're buying a fifth a day of vodka, then I think the court will jump to the conclusion that they're consuming it, and that's in excess. And there are some other examples, DUIs. If there are a few
Sure.
DUIs, certainly more than one is suggestive of a problem. And maybe one is, but certainly more than one. But those aren't often available. And often it's a matter of, the client is saying, Joe, I've seen her get drunk, on every 4 or 5 events a month, she gets drunk. And I say, fine, we need witnesses to this. Well, I don't have anybody who's going to get on the stand and testify.
Mm-hmm.
Or our client thinks they will, and then we approach them. It turns out that they're on the day of trial unavailable. So I guess we'll wrap this point up by saying, so there are really 2 large aspects of this discussion. One is, what are the, assuming you can prove the incidents, what do they consist of, and are they sufficient? And number 2, can you prove the incidents? 2 almost independent questions. Why don't we go ahead and talk here about some of the issues that are perhaps on our clients' minds around the beginning of the year. We're going to sort of step into the minds of our viewers. And let me start with this, Heather. As you worked in the courthouse, prior to coming on board with Cordell and Cordell, you were in a position in the clerk's office, prior to being a lawyer, in fact, you were in a position in the clerk's office to observe all the filings. You were involved in all those each year. And I'm curious about what you saw around the beginning of the year. Did you see more modifications, or what did you see?
Well, I believe at the beginning of the year, probably the first couple weeks in January, there wasn't a lot trickling in because by way of December, the holidays at the end of December and whatnot, I think most people, if they're planning to file in the new year, they meet with their lawyer once everybody comes back off of the holiday break.
Right.
Probably about the middle of the month is when I did see a lot of divorces being filed and a lot of child custody modifications being filed. Not so much monetarily. I think it was more people's mindset. If I can speak for them, it's this is the new year. I want to get a fresh start. I want to get more time this year with my children. I want to spend more time with them. As far as the divorce aspect, obviously, this is the new year. Mm-hmm. If I'm going to get a divorce this year, what better time than the beginning of the year to start that out? Right. Because as we all know, most clients have the perception that they file for divorce and in 2 months it's over with. or that's what they hope for when they come in to see a lawyer. Is the first question I'm often asked is, how long will this take? I want to be divorced in a couple of months. And